in the matter of National Iranian Oil Company and Crescent Petroleum Company International Ltd and another.
Yes, Mr. Bailey.
May it please the court, my lords, my lady, I appear in this matter together with my learned friends, Miss Jessica Sutherland and Frederick Elliott, on behalf of the appellants, and my learned friends, Mr. Ricky Dewan of King's Counsel and Dr. Tariq Falk and Mr. Mays Farhan appear on behalf of the respondent, Crescent.
Yes.
Now, my lord, before we begin, I wonder if I could make a short point about the running order.
Yes, that would be helpful.
The reason I say that, my lord, is because, as your lordship will know, before the court is my client's appeal, which is brought with the permission of Mr. Justice Butcher from his order of the 21st of October last year, whereby he dismissed my client's Section 67 arbitration claim pursuant to CPR Part 24. That appeal is before the court. But in addition to that, my lord, before this court today is also a cross-application brought by Crescent for permission to appeal. And that application was adjourned for consideration by the full court pursuant to an order made by my Lord Justice Mayles.
Yes.
On the 28th of February of this year. Well, perhaps we can just very briefly look at it. It's in Core Bundle 2, or Volume 2 of the Core Bundle, at page 431. Tab 20 at page 431, an order dated the 28th of February. The decision made was that the application for permission will be determined at the hearing of the appeal. And the reasons given, the question whether the Court of Appeal has jurisdiction to grant permission to appeal on the Section 73 issue merits consideration by the full court. If the court has such jurisdiction, the court will decide whether permission should be given, and if so, the appeal will follow. There's a further point made in paragraph 3. Now, I'm obviously in the court's hands, but in our respectful submission, the most appropriate course would be to hear Crescent's application for permission to appeal first, before hearing my client's appeal. We make that suggestion really for two practical reasons. The first is that, as is apparent from my Lord Justice Mayles' judgment, the application for permission to appeal gives rise to an important but nonetheless a relatively short point of law in relation to the jurisdiction of this court. And secondly, if having heard argument, at least on that point at least, the full court were to rule that it did not have jurisdiction to grant permission to appeal, or indeed that the application should be dismissed, then that would obviously have the beneficial consequence of considerably shortening the duration of this hearing, and obviously therefore leading to a saving in costs. And well, that's the reason.
Or conversely, I suppose, that if the cross-appeal were to succeed, then your appeal wouldn't arise.
Well, my lord, that's one way of looking at it, my lord. But
have you discussed this with Mr.
Well, I have, my lord. I have discussed it with a friend. As I understand it, he opposes the idea, partly on the basis of there being a suggested agreed running order. But my lord, we're not aware of any agreed running order for today.
I was rather wishing I'd ordered you to produce an agreed running order, but I think that slipped through my net. Indeed,
my lord. But anyway, my lord, it's a matter for you, lordship. It's very much in the court's hands, but that seems, in our respectful submission, the most practically sensible way to proceed. Agreed. So we just deal with it. I've agreed. If it saves time,
I think what we'll do, Mr. Bailey, is we'll hear your appeal, and then we'll see where we go with the jurisdiction point.
Well, as your lordship knows, my client's appeal with the leave of the court below against the summary dismissal of my client's Section 67 arbitration claim pursuant to CPR Part 24, which is the summary judgment provision within the civil procedure rules. Now, the judge's reasons for his order are to be found in paragraphs 51 to 62 of his judgment. And that can be found in Core Bundle Volume 1. Tab 11.
Yes.
Pages 132 through to 135. And in addition to that, my lords, his further reasons, which expanded upon what he said in paragraph 62 of his main October judgment, are to be found at tab 13 of the same bundle at pages 138 to 143. And in particular at paragraphs 12 to 14, he provided further reasons for the conclusions he expressed in paragraph 62 of his main judgment.
Yes.
Now, in our respectful submission, in reaching his decision, the learned judge made 4 separate and independent errors of principle, each of which is reflected in the 4 grounds of appeal on which my clients rely. Now, what I propose to do, my lord, in terms of where I'm going, is that I propose to address each of the individual grounds of appeal in succession. Before doing that, I should like to spend a little time, not very much, a little time with some introductory observations on the background to the underlying dispute, and to take you briefly to certain passages in the awards of the tribunal which address Crescent's claim for damages and how it evolved, and what it amounted to in relation to its claim for damages in relation to its alleged liability to CNGC and the third-party CNGC contract.
Mm-hmm.
So, my lord, can I start just by showing you one passage in the tribunal's first award, which is in Supplemental Bundle 1, that's tab 3, page 114. And my lord, this award was published in July of 2014.
This is the jurisdiction.
Yes,
liability.
liability and jurisdiction award. Well, there's only one paragraph I want to show you, my lords. It's at, my lady, it's at paragraph 8 on page 114. And just to set the background, really, Crescent claims that in breach of the GSPC, that's the contract between my clients and Crescent, NEOC failed to deliver gas on the 1st of December 2005, or at any time since that date. Crescent originally sought specific performance of the GSPC, together or alternatively with compensation for alleged losses resulting from NEOC's delay in performance. So the original claim was not a claim for lost profits or liability at all. It was a claim for specific performance and damages for delay. And then the final sentence, at the hearing on the 11th of February 2013, Crescent stated that it was amending its claim to seek only damages to be assessed and not specific performance. So that was the position at the time the liability and jurisdiction award was published. And then, of course, we know that the tribunal then entertained argument on remedies, and they produced their award called a partial award on remedies on the 27th of September 2021.
Well, the relief which they were seeking was set out in more detail at paragraph 223 of that award.
Well, my lord, yes,
Relief
indeed.
sought.
That's exactly right. That's where I was going to take, my lord, if I may, now. This award is actually in Core Bundle Volume 2, tab 17.
Oh no, I was looking at the jurisdiction award, paragraph 223,
Ah,
where under the heading relief sought, There are claims for declaration, specific performance, and then indemnity for compensation to pay its affiliates.
My Lord, yes.
Isn't that actually the claim that we're now concerned with?
Well, my Lord, it's in a way, I'm not disputing that, my Lord, and it certainly is developed, and I explain why. Because there was more specific consideration given to the claim for damages in the partial award on remedies, as one would expect. And my Lord, as I say, that award was published on the 27th of February 2021, and it's of course the award in respect of which the Section 67 challenge is made. And as I say, it's in Core Bundle Volume 2 at tab 17. And if I can just begin by taking you to page 256 of the bundle. This is the heading, heading number 4, the claims for relief. I don't know if your Lordship sees that.
Yes.
And at paragraph 286, paragraph 86 of its memorial on remedies, Crescent sought the following relief. 1. An award in respect of its quantified lost profits and the quantified damages it claims in relation to CNGC's lost profits between the commencement date and the date of the award by reason of Neox breach of the GSPC in the sum of $13.8 billion. That way of putting the claim was unsustainable, not least because CNGC was a separate legal entity and obviously not party to the arbitration. And for that reason, the claim changed, as one sees at paragraph 288 across the page at page 257, where the tribunal said, paragraph 250 of its reply on remedies, Crescent stated that it sought the following remedies. Number 1, the primary remedies CGC seeks are an award in respect of its quantified lost profits between the commencement date and the date of the award in the sum of $4.2 billion. And then paragraph 2, and this is obviously important because this is the source of the claim which gives rise to the issue before the court. An award in respect of all liabilities of CGC to CNGC under the CNGC GSA in respect of CNGC's lost profits between the commencement date and the date of the award in the sum of $8.8 billion. So that's the second aspect of the claim, which gave rise in due course to the jurisdictional issue, which forms the basis of our Section 67 claim. This is further explained, my Lord, in paragraphs 530 paragraph 530, which is on page 337. And it's under the heading, which is heading C. You see that on the previous page at the top of 336. CGC's case on its recoverable losses. There's a section on the nature of the claim. And then importantly, my Lord, at paragraphs 530, under the heading Formulation of the claim. Over time, Crescent advanced its case on damages in a number of different formulations. Initially, adopting a broad approach that treated CGC and CNGC as a single entity, Crescent made a global claim based on the difference between the price that NEOC would have been paid by CGC for the gas and various prices that Crescent alleged would have been obtained on resale by CNGC of the sweet gas and products after allowing for processing costs. So that was the original way it was put. And then in 531, and of course this is again significant because it's the way in which the case was put by Crescent which gave rise to the jurisdictional objection. 531 says, more recently, and that's a reference back to the reply submissions, Crescent has claimed the loss allegedly suffered by CGC as falling into two categories. One, the profit that CGC would have made on its on-sale contract with CNGC, and two, its liability to CNGC in respect to the losses that CNGC sustained in respect of onward sales to end users. So that was a breakdown of the two ways it reformulated its case. And what we'll see, what is the reason Category 2 gave rise to a jurisdictional objection is because in the absence of a judgment or an award or a settlement or even a claim by CNGC against Crescent, NEOC's case is, and we would submit always has been, that the dispute as to the existence and extent of Crescent's alleged liability to CNGC under the terms of a separate contract is a matter, and I use the word matter purposefully, is a matter which is beyond the scope of the arbitration agreement in the contract between NEOC and Crescent. That is essentially the objection which NEOC pursues. Now, going on in the award, my lord, can I just briefly show you section D?
Just before we get there, at paragraph 555, the arbitrators state their understanding of the jurisdictional objection and give their answer to it.
My lord, yes.
Is that the only place they deal with that point, or is there other
that's
fuller material later?
That's the only place where they deal with it. I will come to that, my lord.
Yeah, I mean, that's really more on the cross appeal, isn't it? But just to identify it as we go, as it were.
Indeed, my lord. I was going to show you the relevant paragraphs, of which that is obviously one of them.
Yeah.
In fact, going into the award, my lord, section D. Or rather, section E, my lord, which begins at paragraph 545, page 339. Now, this is the section which addresses the so-called Category 2 claim, the one that I've identified, and with which we're concerned. What I'd ask you to note, my lord, in paragraph 545, Crescent says that CNGC would have made profits, that CGC is liable to compensate CNGC for those for the loss of those profits. And at the bottom of the line, page, the last line, Crescent does not seek declaratory relief in respect to this claim. It says the amount of the claim has been quantified. An award of damages in the quantified amount is sought. I'd also ask you to note, my lord, paragraph 549. According to Crescent, the CGC CNGC GSA is essentially back-to-back with the contract between Crescent and NEOC. But the tribunal rightly observed there are, however, some differences between the two. One difference is that CGC agreed to supply a somewhat greater quantity of gas to CNGC than it was entitled to receive from NEOC. And then in paragraph 550, the liability alleged by CGC is a liability in damages for the loss sustained by CNGC of the profits that it would have made derived from the on-sale of gas. And then at paragraph 551, my lord, the tribunal identified the various objections of principle that were taken by my clients, and for present purposes, subparagraph 2 is the relevant one to note. The tribunal has no jurisdiction to resolve issues between CGC and CNGC, is how they described it. And then, my lord, as your lordship has rightly said, at paragraph 555, the tribunal deal with the jurisdictional objection. They say that the respondent has raised a jurisdictional argument to the effect that this tribunal has no capacity to resolve any dispute between CGC and CNGC. The CGC-CNGC GSA contains an arbitration clause which, so far as the evidence shows, has never been invoked and is materially different from the arbitration clause applicable to the dispute between NEOC and Crescent. However, CGC is not inviting the tribunal to resolve any dispute between CGC and CNGC. In the context of a dispute between CGC and NEOC, CGC is inviting the tribunal to reach a conclusion that CGC is liable to CNGC in a certain amount and to award damages against NEOC and compensate CGC for that liability. And therefore the argument advanced by my clients is misconceived. Now, two short points. As we'll see in the context of the alleged cross appeal, what the tribunal said has no legal or evidential weight in the context of proceedings pursuant to section 67. But nonetheless, the reasoning of the tribunal effectively adopts that contained in a footnote within a book authored by Muston and Boyd on commercial arbitration, on which the respondent Crescent relied. Now, the relevant passage in Muston and Boyd is in the authorities bundles, volume 5. I'll quickly show you that, my lord. Tab 64, page 1525. Now, there's a paragraph in the main body of the text on page 73. It's halfway down, just opposite the top hole punch, beginning an arbitrator whose powers, if you can see that, halfway down, just above the 2 lines effectively above the top hole punch, an arbitrator whose powers are derived from a private agreement between A and B plainly has no jurisdiction to bind anyone else by a decision on whether a patent is valid, for no one else has mandated him to make such a decision, and a decision which attempted to do so will be useless. This is a question of jurisdiction, not of arbitrability, and we can see no reason why an arbitrator cannot conclude the issue of validity as between A and B if the issue is one which they have mandated him to decide. So that was the sentence in the text. And then the footnote 11, which is important in the sense that it was what was relied upon by Crescent, and one can see it's essentially the reasoning which the tribunal adopted. Muston and Boyd say, the position is, we suggest, similar to that which does from time to time arise in practice, where in order to resolve a dispute between A and B, an arbitrator has to decide an issue arising under a contract between B and C. There is nothing inarbitrable about such an issue, and the arbitrator commits no impropriety by deciding it, although his award will have no effect at all on C. Nor does he exceed his jurisdiction in doing so, for he is not purporting to act as arbitrator in relation to the contract between B and C, in relation to which he was not appointed, but instead he is deciding under the contract between A and B an issue which, albeit involving C, does properly arise under that contract. Now, that's the essential reasoning which the tribunal adopted in paragraph 555 for rejecting my client's objection to their jurisdiction to decide the question of the existence and extent of Crescent's liability to CNGC under a separate contract. Now, can I make 4 short introductory points by reference to that passage in Muston and Boyd? The first point is this, that as you will have seen, there's no authority cited in support of the proposition advanced in footnote 11. And in our submission, there's an open question as to whether or not it is correct as a matter of English law. But be that as it may, my second point is this. More importantly, the scope of an arbitral tribunal's jurisdiction will always depend upon the meaning of the arbitration agreement as interpreted in accordance with its proper law. And the third point, my lord, is that it's common ground between NEOC and Crescent. The proper law of the arbitration agreement in the NEOC Crescent GSA is Iranian law, not English law. Now, the fourth point is this. Applying the principles of Iranian law identified by Dr. Makrami in his report, whatever the position may be under English law, what we submit is that the propositions advanced in footnote 11 do not reflect Iranian law, and therefore it's not the position in relation to the arbitration agreement at issue in this case. Now, can I remind you very quickly of how we put this point in our main skeleton argument? which is in Court Bundle 1, at tab 2, paragraph 29.7.
Have we finished with the award?
I beg your pardon?
Have we finished with the award, or are we still looking at that?
My lord, I was going to...
That's all right. I'll keep it, if we are, I'll keep it out. Just a,
Keep it handy.
just a question of paying the next, that's all. Your skeleton,
Argument,
tab
my
2.
lord. Tab 2 of Core Bundle 1 at page 33 is a section D, the arguability of Neox case. And what I was going to show you, my lord, my lady, is subparagraph 7 on page 34, where we say the assertion in footnote 11 of Mustle and Boyd is predicated on the following logic. 1. The tribunal does not exceed its jurisdiction because the tribunal is not purporting to decide a dispute in relation to the contract between B and C, and its ruling does not bind C. And 2. The issue involving C properly arises for determination under the contract between A and B. So that's the essential reasoning in the footnote. Now, what we submit is that, considering the matter from the perspective of Iranian law, the notion that the tribunal is not deciding an issue between B and C is artificial and unsustainable. And as you'll see from the footnote, we draw an analogy in this context between the attempt in the context of anti-suit injunctions some years ago to say that they don't interfere with the jurisdiction of a foreign court because they only act in personam. And Lord Justice Mayles will probably readily remember that argument. There was...
No, I've excised it from my memory banks.
And indeed the European Court, as your Lordship knows, the European Court of Justice did very much the same thing when they found Lord Hobhouse's explanation effectively to be a mere sophistry, as we put it, and unreal. And we say that the same is very much true in the context of what Mustle and Boyd say in footnote 11 when looked at through the perspective of Iranian law. And as we continue to say in subparagraph 7, to all intents and purposes, in a matter of common sense, that is exactly what the tribunal is doing. Once the tribunal determines the issue involving C, then unless C has intervened in the arbitration between A and B, the decision of the tribunal gives rise to a risk of inconsistent decisions and or a potential windfall. It also violates C's established right to a hearing as a matter of Iranian law. And as explained above, it's a fundamental policy of Iranian law that arbitration agreements are narrowly and restrictively construed in order to avoid these consequences. So, whether or not that submission is correct, ultimately correct, it of course remains to be seen. But for present purposes, what we respectfully submit is that NEOC has an arguable case to that effect, which gives rise to tribal issues and which ought properly to be tried.
Well, what is the claimant supposed to do? It has a claim that, as a result of breach of contract, it has incurred liability to somebody else. How does it pursue that claim on your theory of Iranian law?
Well, my lord, how it would pursue that claim in circumstances where there be no claim made against it, no arbitration commenced, no judgment, no award, but supposed it in due course it might become liable to a third party. Well, my lord, those circumstances, an appropriate remedy may well be a declaration.
But the respondent, the person in NEOC's position, wouldn't be bound by the arbitration between the two Crescent companies, would it? If there was an arbitration saying that the damages payable by CGC were enormous.
Well, my lord, if there was an award between CGC and CGC, and there was a payment made pursuant to that award, that would be the liability. That would be the loss. Now, there may be questions to what extent that loss is recoverable, but that would crystallise and fix the amount of the loss.
But isn't NEOC entitled to say, well, you failed to take all sorts of good points which would have given you a defence?
Well, my lord, certainly NEOC is entitled, or would be entitled as a matter of law, because we don't actually know what the Iranian law position is. It was an Iranian law contract. Certainly, as a matter of English law, if that were the relevant legal system, it would be entitled to say that the judgment is wrong.
So that would involve the NEOC Crescent Tribunal having to consider those arguments.
Well, my lord, yes, but in a very different context. What the tribunal in that context would be doing is assessing whether or not the award constituted a true reflection of the loss that was suffered by Crescent. Likewise, I mean, the other example in this context you could put to me is to say, well, what happens if they entered into a settlement agreement? Surely the NEOC would be able to say, well, I don't accept that the settlement agreement establishes that you've suffered a loss or that you're liable. Now, my lord, in that context, if there was such a dispute, then according to Muscle and Boyd, as a matter of English law, if that were right, the tribunal was seated in England applying English law could consider that issue and make a ruling about it. If the matter were governed by Iranian law, then what we would submit would be appropriate is that that issue would not fall within the scope of the arbitral tribunal jurisdiction between Crescent and my clients, but rather would have to be resolved by the jurisdictional tribunal or court which had jurisdiction over the settlement.
Sorry, are you saying that the same would, in the settlement case, I think you're saying you'd end up in the Iranian courts because the arbitration agreement doesn't cover it?
Sorry, I may have run too fast here.
Or are you...
I'm producing a hypothetical to the effect that the point my Lord Justice Mayles put to me, well, imagine there was an award or a judgment. You wouldn't be bound by that, and the tribunal could assess whether the award or the judgment properly reflected the liability. And I agreed with him, as a matter of English law at least. I don't know what the position in Iranian law would be. Then I posited the next example, after the one my Lord put to me, which is, well, imagine there was a settlement agreement between Crescent and CNGC. And Crescent relied upon that settlement agreement and said, well, look, that's crystallised my loss. I can now recover the amount of my liability as established by that agreement. And I was postulating the possibility there may be a dispute as to the meaning of that agreement, whether in fact it did establish a liability, let's say. This is hypothetical. And what I'm submitting is that whatever the position may be under English law, as a matter of Iranian law, in those circumstances, a tribunal having jurisdiction under an arbitration agreement governed by Iranian law, the same terms as our agreement, would not have jurisdiction to decide that dispute under the settlement agreement as to what it means.
I understand that, but I also want to go back to the question that Lord Justice Mayles posed, which was, if there is an award, your answer is that under English law the tribunal could consider it, but we're not in an English law scenario, we're in an Iranian law scenario. What are you saying is your case?
Well, my lady, that is a hypothesis on which there isn't any Iranian law because it didn't arise.
Right.
Unfortunately, what we're dealing with, as I was about to show you in the final passages in the award, which I was going to take you to, perhaps I can do that now. We're dealing with a situation where there was no award between Crescent and CNGC. Not only was there no award, it was said, at least at the time, there was no settlement agreement, but there's a wrinkle on that. But also there was never even any claim made by CNGC against Crescent. So that was the relevant scenario we addressed, in which the Iranian law goes to. It's unfortunate I can't help my lord and my lady about what the Iranian law position would be in relation to judgments, although I can help in relation to the settlement agreement point, because that's wholly analogous to where we would submit in the case presently before the court. But just to show my lord, my lady, what the tribunal said in their award, which I think we kept out. Or at least I need to find where I left it myself. I think it was Big Core Bundle 2, I think. Bundle 2, my lord, back in the award. The paragraphs I wanted to show you were paragraphs 567. I think we left it at page 342, paragraph 555, which dealt with jurisdiction. Then there are paragraphs under 5, force majeure, 6, foreseeability, and 7. And these are the paragraphs I wanted to show you, my lords, my lady, under the heading "No claim for damages advanced by CNGC." So NEOC submits that the absence of evidence of any claim made by CNGC upon CGC is fatal to CGC's claim that NEOC is liable to indemnify CGC in respect of its liability to CGNC. 568. The claimants do not seek to establish such liability by pointing to a court judgment or arbitral award which declares or recognises its existence, nor is there evidence of any formal admission of liability by CGC or any recognition of such liability in the financial accounts of CGC. And then paragraph 569, Crescent submits that although there is no judgment or award or agreement by reference to which the tribunal can determine the amount of CGC's liability to CNGC, the evidence is sufficient for the tribunal to quantify CNGC's lost profits and thus to determine the extent of CGC's liability. CGC is acknowledging, in fact asserting, its liability to CNGC in these proceedings. And they say in 570, the issue is governed by Iranian law, cite some Iranian law, and then they set out their conclusions at paragraph 8, heading 8, paragraph 572. As to CGC's putative liability to CNGC under the CNGC GSA and UAE law, which is assumed to be the same as English law, it is a case of a seller's liability to a purchaser for failure to deliver goods, the unprocessed gas. The loss suffered by CNGC was the natural and ordinary consequence of non-delivery, and there is nothing in the sales contract which relieves the seller from such liability. And then the last two sentences are significant. Although there has not been a formal claim, a finding or admission of liability, as between CGC and CNGC, CGC does not appear to have any answer to a contention that it is liable for damages for non-delivery. Such a liability is no mere technicality, since CNGC, although a Crescent subsidiary, has important minority shareholdings. For these reasons, the tribunal finds that CGC has proved that NEOC's failure to supply gas to CGC resulted in the liability that CGC alleges that it has incurred to CGNC, subject to quantification. Now, my lord, I'll go on just to show you one or two final paragraphs, but before I do, can I make two observations on the paragraphs I just referred to? Mm-hmm. The first is this, is that in both paragraphs 569 and in 572, the tribunal says that there was no settlement between Crescent and CGNC. Indeed, that was how the tribunal, and indeed my clients, understood the position to be when the award was published in September of 2021. However, in fact, the evidence before Mr. Justice Butcher and before this court would suggest that that was not in fact the case. And this point was first raised by Mr. Dworsky in his second witness statement, which is in the Supplemental Bundle, Volume 3. I could just briefly show you that. I'll explain the relevance of this in a moment. Just bear with me for a second. So Supplemental Bundle, Volume 3, tab 13. Page 1257. It's paragraph 24. Mr. Dworsky says, CGC is a 65% shareholder in CNGC, with the other 35% held by Dana Gas, in which Crescent has significant interests, and with which it is closely associated. Crescent has also thus argued that any requirement for these parties to have sued one another in formal proceedings to artificially produce a judgment or award for use in the first arbitration would be unrealistic. Indeed, CGC and CNGC have since reached a negotiated settlement of CNGC's claim for the CGC liability losses, as well as in relation to some of the CGC liability for third-party losses. That's what he says there.
So it's not that what was said to the tribunal is wrong. It's simply that events have moved on. Is that the position?
No, the word "since" is somewhat ambiguous. It's not quite clear from what date he's referring to.
Right.
Now, the point was addressed, my lord, in Mr. Howarth's third witness statement, which is in the same supplemental bundle. So if we just turn on, my lord, to paragraph 1270 in the same bundle. I don't propose to read it all out, but the relevant paragraphs are paragraphs 14 and 15 on page 1270 and page 1271. I'll just pick out some key points. Paragraph 14, Mr. Howarth refers to paragraph 24, which I've shown you, Lordships, and my lady. And then he then states, indeed, CGC and CNGC have since reached a negotiated settlement. And in paragraph 15, Mr. Howarth says, I find this to be a curious sentence. This is the first time that Mr. Darwowski has mentioned such a negotiated settlement. And I understand him to be referring to a suite of settlement documents entered into around 16th of April 2018, i.e. over 2 years before the final hearing took place in the remedies phase of the first arbitration. And then he refers to the settlement documents comprising of releases and agreements and so on. And how we know about this. The settlement documents were produced by Crescent in November 2021 in response to a specific document production request made by NEOC in the second arbitration seated in Geneva. And then he makes three further points. The first being that since is potentially misleading because it doesn't say since when, but in fact the settlement documents were concluded several years before the partial award on remedies was published. Secondly, as we know, Crescent kept the settlement agreement to itself, didn't disclose it in the first arbitration, only disclosed it in response to a specific request from my clients in the second arbitration. And then thirdly, and perhaps this is the most significant point, thirdly, while I do not know the reason why Crescent did not rely on the settlement documents, I note that it may be because, under the settlement documents, CGC has purported to omit liability to CNGC for the sole purpose of effecting the recovery of sums from NEOC, and that further, CGC is only obliged to make payment to CNGC if and when CGC receives payment from NEOC. This is apparently at odds with what Crescent's counsel told the First Arbitration Tribunal about the nature of CGC's purported liability to CNGC on day 2 of the remedies hearing, quote, that liability is admitted in this amount intra-group. Now, this amount, as the court will know, in the context of that statement, is some $8.8 billion. Now, why am I showing you this? Why is it relevant? Can I assure the court that I'm not making a disclosure point? The reason I'm showing it and bringing it to your attention is because what it does, in my respectful submission, is it brings into focus a key principle of Iranian law that's identified by Dr. Makrami in his report and on which my clients rely, but which was ignored by the learned judge. One of the most important principles and policies of Iranian law on which we rely is that an arbitration agreement governed by Iranian law is to be construed narrowly or restrictively to avoid any risk of inconsistent decisions between different tribunals, as this could lead to confusion and potentially an unjustifiable windfall. Now, the reference to that is paragraph, in our skeleton at least, is, perhaps we don't need to turn it up, but paragraphs 27.3 of our main skeleton, which is in Core Bundle 1 at tab 2, paragraph 31, and we give cross-references there to Dr. Makrami's report. Now, what has happened in our case, this case, as we've seen from the evidence I've just shown you, is that the way in which the tribunal approached the case demonstrates the real risk of potential mischief, which this principle of Iranian law seeks to avoid. Perhaps I can try and put the point in a slightly different way, which is to say that if an arbitration agreement is construed as being wide enough to enable the tribunal to determine the existence and extent of an alleged liability to a third party under a separate contract, then in our submission the risk of injustice and potential windfall is self-evident. An obvious example of that is where a party such as Crescent may make a very substantial recovery in an arbitration in respect of a putative liability to a third party, and then the third party fails to ever commence a claim, with the consequence that any claim it may have had becomes barred by the effluxion of time.
Well, I'm not sure I'm following this. The principle you say your expert says is part of Iranian law is that you have to avoid the risk of inconsistent decisions. But if there's a settlement, there's no risk of inconsistent decisions at all. There simply isn't going to be an arbitration under the CNGCG contract. And it seems to me that, I mean, is this analysis right? That the tribunal has decided that there is a liability, and that it's either right or wrong about that. That's not capable of being challenged, is it? The question is whether the tribunal has jurisdiction to award damages in respect of that liability. And
Well,
nothing in what you've said. I mean, if the implication is, I'm not saying you've said this, but suppose you were to say that the settlement agreement is some kind of put-up job, or it doesn't represent a genuine liability, well, don't need to go into all that, because the arbitrators have said that there is a liability and this is what it is.
Well, perhaps I can backtrack just slightly, because I may have not made the point I'm making as clearly as I should have done.
Yeah, I'm sure it's my
The point I'm trying to make is this. One of the key principles of Iranian law on which we rely is that arbitration agreements governed by Iranian law are construed restrictively to avoid the risk of potential confusion and inconsistency with other decisions of other tribunals, and to avoid potential windfalls. Now, I was giving one example of how the approach the tribunal took could give rise to windfall, and that is where there's an alleged liability to a third party, but the third party's never made a claim. The tribunal proceeds, nonetheless, to assess that theoretical claim and make a determination that liability exists and the proper quantum of that claim is X billion dollars. So Crescent, or the party making that claim, recovers X billion dollars. There's no obligation to pass it on to anybody. But then what happens is that the so-called putative claim is never advanced. The so-called claim becomes time-barred by the effluxion of time, therefore can never be pursued. In those circumstances, it's clear that the approach the tribunal adopted gives rise to a potential windfall. And that's the theoretical point. The point I was making by reference to the evidence of Mr. Jaworski and Mr. Howarth is a further illustration of potential mischief that the approach the tribunal took could result in, is where a party enters into a settlement agreement with a third party saying, I'll pay you 50% of what I recover, let's say, but then goes to the tribunal and says, well, actually, I'm liable for $20 million or whatever it may be, even though it's not actually ever going to have to pay that over to the third party. Keeps the settlement agreement to itself and asks the tribunal to make this determination in the abstract of a theoretical liability to a third party who's never made a claim, or never sought a judgment or an award, or even a settlement agreement, which the tribunal's aware. The risk of injustice and mischief is clearly apparent. Now, I'm using these as examples to justify, or rather to explain, the commercial common sense, if you like, which lies behind this principle of Iranian law on which we rely.
Can I just be clear, because I may be getting confused. What we're talking about is Iranian law as it affects the scope of the agreement to arbitrate, not the scope of a damages claim.
Quite.
And just taking your argument step by step, you say essentially that's a reason to construe the arbitration agreement that way. But it still leaves these questions out there for determination at some point.
Quite.
You say, I think this is a question I was asking earlier, I think you're saying, at least in the context of a settlement, that those should be dealt with by the Iranian courts.
Well, my lady, perhaps I can't necessarily see all the whole way to the end of the race, but let me try and answer your point this way. What we're concerned with is the construction of an arbitration agreement governed by Iranian law, and what we say, adopting the appropriate approach under Iranian law, namely restrictive construction, which is designed to avoid the potential risk of inconsistent decisions and windfalls. What that means is that an issue or a dispute as to the existence and amount of a liability to a third party under a third party contract falls outside the scope of the arbitration agreement, outside the scope of their jurisdiction. Now that doesn't mean, this is perhaps important, doesn't mean the arbitration tribunal doesn't have jurisdiction over the claim for damages in respect of a liability to a third party. It still has jurisdiction over that claim, but what it can't do is assess the existence and amount of the liability that would justify a damages award. It either has to adjourn the claim, or it either has to give declaratory relief. What it can't do is go ahead and theoretically assess what the liability of this theoretical claim is, neither its existence nor its amount.
Okay,
In other words, they'd have to treat, what they should have done, this tribunal, is treated the claim for damages with respect to the liability to CNGC in the same way it treated the claims for liability and damages claim for a liability of CGC to other third parties, in which case the court said, the tribunal said, we simply don't have enough information at the moment to make a ruling one way or another. Now,
okay, so just help me with this. The declaratory relief, what might that be? That in principle there's the damages.
Yeah, the declaratory relief. I mean, whether it's available in Iranian law is another matter. But in theory, the way it would work is, and this happens all the time in arbitrations, is somebody says, well, I'm going to be liable to the owners because of your breach of the charge party, but there's no claim, there's no liability. A tribunal may well say, well, I'm going to give you a declaration that you are entitled to damages in relation to any reasonable liability you assume or any binding court judgment or award that's published. So I mean, I can't formulate a precise form of the declaration.
I think the submission you just made, if I heard it right, was that the arbitrators can decide, under Iranian law, that there is a liability to the third party under the other contract, but they can't quantify it. Now, if that is what you said, then they are deciding a question of liability
Well,
under
Lord,
the other contract.
I don't believe I
or
said
they
that.
may-
If
did
I
you
did
not?
say it, if I did say it, it's inconsistent with everything
Right.
I've said in writing.
Well, that's why
Then, my lord,
perhaps I misheard you.
what the tribunal can't. I mean, I'm assuming, of course, there's a dispute or an issue or a difference between the parties to an arbitration agreement as to whether or not a liability to a third party exists. Now, if there is a dispute or a difference, then that is a difference or dispute which the tribunal itself cannot decide, both as to the existence and the extent of that liability.
So you're saying the declaration would be effectively if you end up being liable
Quite.
to your subsidiary,
Quite. Or to
Then-
anybody. Then we can award you the amount of that liability, assuming we go through the other hoops.
okay, but then that assumes that there can't be a subsequent dispute about that liability, which is the point we were discussing earlier.
Well, in that, as I say, I don't know. We haven't got to that point.
Okay.
It's a hypothetical scenario which I'm afraid wasn't addressed in the arbitration. All I can say, as I've tried to be helpful in saying, is that if there was a settlement agreement, let's say, between CGC and a third party, and NEOC would say, well, actually, there's an issue here because we don't accept there is a liability established by the settlement agreement. I mean, it's highly unlikely, but it's theoretically possible that NEOC say there's a dispute as to whether or not this agreement establishes a liability. Now that...
Well, it's, just to interrupt, sorry, it's perfectly possible. There might be as I think there possibly was, an argument, well, you weren't liable at all because you had a cast iron defence under a force majeure clause.
Well, Lord, yes, that was in relation to the GSPC, the contract between Crescent and its subsidiary.
Yeah.
Yeah, and that's one of the issues we say the tribunal had no jurisdiction to resolve.
Yes. So that would arise if there was a settlement.
Well, likewise, that's why I'm saying if there was a settlement agreement, that dispute, that kind of issue arose, it would also fall outside their jurisdiction.
Yeah. Okay.
What I'm saying, essentially, in practical terms, somebody comes along with a settlement agreement saying, I've incurred this liability, in fact, I've paid the amount that the settlement provides for, then there's unlikely to be any dispute as to what the loss was. There may be a dispute as to whether or not the amount agreed and paid was reasonable. That's a different issue. The existence of loss will be established. Now, if, however, hypothetically, somebody came along with a settlement agreement and there was an argument, well, in fact, there is no, but they hadn't made a payment, so there was no actual loss, but there was an agreement to pay, let's say, or an alleged agreement to pay, and that was in dispute, then what we would submit, by analogy from the principles that we know about from Dr. McCramy, if in that settlement agreement was a jurisdiction or an arbitration clause, let's say, that dispute would have to be resolved by that chosen forum, not by the arbitrators having jurisdiction over the dispute between, say, NEOC and Crescent. So I hope I may have laboured this, but I hope I've at least made it clear what we submit.
Okay, let's move on to the next point, and we'll reflect on that.
Yeah, I mean, perhaps it's a much simpler way of putting it than I've attempted. What I'm suggesting to say would be that if you look at a settlement agreement, for example, within it, it may have its own arbitration agreement or its own jurisdiction clause. You know, any dispute arising under the settlement agreement is to be dealt with by a particular jurisdiction. Now, what we submit is that if there was a dispute as to the effect of that settlement agreement, in other words, whether or not it did establish the existence of a liability, or indeed its amount, then that would be a dispute that the tribunal between Crescent and NEOC would not have jurisdiction to decide. It had to be decided by the tribunal with jurisdiction over the settlement agreement.
But NEOC would not be bound by that determination, would it? Or would it?
Well,
so, it seems to me in your scenario, either NEOC is being bound by an arbitration agreement in a contract to which it is not a party, which seems contrary to everything your expert is saying, or these points all have to be determined under Iranian law by the Iranian court as the default jurisdiction, because neither arbitration tribunal has jurisdiction.
Well, my lord, it can't be the case that that nobody has jurisdiction to decide the issue. An issue as to the existence of a liability between B and C has to fall within the jurisdiction of one tribunal or another. Now, what we submit is the tribunal with jurisdiction to decide that issue is the tribunal with jurisdiction over either the settlement agreement or the third-party contract. Now, whether or not that is going to be binding on NEOC as a matter of Iranian law, I'm afraid to say we don't know the answer to that, because it certainly wasn't an issue that arose. It may be a party could only challenge, for example, a judgment of an Iranian court, or if it was obtained by fraud. I just don't know what the grounds would be. But the reality is there's unlikely to be any, I mean, it's possible there could be a dispute as to whether or not the judgment is a valid judgment establishing a loss. But the reality is that once you get a judgment, an award, or a settlement, what that does is tend to crystallise the loss, because invariably the claimant will have made a payment pursuant to it, and the payment will clearly evidence the existence of a loss. The question then becomes, you know, is the party in breach liable for that loss? Well, another way of putting it is, I suppose, to say this, that in circumstances where a party is saying, I'm entitled to damages in relation to my putative liability to a third party, but he can't produce a judgment, he can't produce an award, can't produce a settlement agreement, can't even point to a claim, and he certainly can't point to him having made any payment. The reality is there is no loss at that stage. It is only theoretical, which is another commercially sensible reason why the tribunal wouldn't go ahead and start investigating these existence and extent of that potential liability, particularly under a separate contract which had its own arbitration clause governed by its own system of law. Well, those are my submissions. Going back, if I may, to the award, just the final points to make. We've seen paragraph 573, page 347, which is the conclusion by the tribunal that there was a liability. In other words, they decided there was a liability by CGC to CNGC under the separate contract, which had its own jurisdiction clause, or rather arbitration clause, providing for arbitration in the UAE under UAE law. We say that finding was outside the scope of the tribunal's jurisdiction. And then as far as quantification of that liability is concerned, there are a number of paragraphs that follow, the detail of which is not important, but can I show you their conclusion on the extent of that liability, which is in paragraph 779 at page 397. What the tribunal did was they assessed the liability, which was said to amount to $8.8 billion. That was the sum that Crescent said that it had admitted informally intra-group of $8.8 billion, but in fact the tribunal assessed the extent of the liability as being just over $1 billion. Well, that's we can put that bundle away, my lord, unless anything else you'd like to look at. The essential point, my lord, and I hope this is clear, is that what NEOC's case is that the tribunal, in adopting that course, namely of determining the existence of a liability under a third-party contract governed by UAE law with its own arbitration agreement, and by thereafter going on to determine the extent of that liability, the tribunal exceeded its substantive jurisdiction. In other words, those matters were not within the scope of the arbitration agreement properly construed in accordance with Iranian law. Or to put it another way, Crescent's liability, both its existence and extent, to CNGC under a separate contract were matters beyond the scope of the arbitration agreement in the agreement between Crescent and NEOC. That's the argument. Whether it's right or wrong, we submit is a question that ought to be tried at a trial where the court has the benefit of hearing and questioning experts on Iranian law. So, against that background, can I turn, if I may, to the four separate grounds of appeal on which we rely? Mm-hmm. Now, the the grounds of appeal concern paragraphs, as we can have learned judge's judgment. Grounds of appeal concern the following paragraphs in the judgment. Paragraph 43 on page 129. That paragraph, the learned judge said, secondly, Mr. Bailey KC pointed out correctly the guidance as to what is meant by the inappropriateness of conducting a mini-trial is provided by the decision of the Supreme Court in Ock Parby and Royal Dutch Shell. So he accepts the basic submission I made. However, he then refers, in fact, to a different section in the judgment, the one I was relying upon, in this context at least. So I'll come back to that. And then, of course, he says at the end of that paragraph, what was an issue was whether and how it was applicable in the present case. Now, we can look at that in due course, but we will submit that what the learned judge, in fact, did was fall foul of the guidance given by the Supreme Court in Ock Parby as the proper approach to an application for summary judgment at an interlocutory stage. But we'll come on to that. The second part of the judgment to which the appeal relates are paragraphs 57 to 59 and then 61 and 62. Paragraph 57 and 58 concern the evidence of Iranian law that was before the court in the form of Dr. Makrami's report. And paragraph 57, what the learned judge does is he says that reading that evidence, at least as far as it's admissible, it gives rise to only three relevant principles of Iranian law, which he summarises, paragraphs 1, 2 and 3. And then there's a further discussion of Iranian law in paragraph 58. And then in paragraph 59, he says, applying the principles of construction which I have distilled from Dr. Makrami's report, I do not consider that Neok's case that the relevant claim fell outside the scope of the arbitration clause stands a realistic prospect of success. Importantly, you'll see in paragraph 59.2, notwithstanding the fact that in paragraph 57.2, he refers to the fact that Iranian law applies a restrictive approach. When you look at paragraph 59.2, you'll see that in the second sentence, the learned judge says, without adopting any pro-arbitration construction or a Fiona Trust presumption, and indeed taking a literalistic approach, the words used are wide, in particular, the words relating to a wide in the category of disputes, controversies, or claims that may relate to the GSPC or to its breach is broad.
I think in due course it would be helpful, at any rate to me, to know whether you agree that the principles set out in paragraph 57 are indeed principles which Dr. Makrami says are part of Iranian law, and further, whether there are any additional principles which Dr. Makrami relies on, and if so, where in his report we find those.
Well, exactly. Well, it certainly will do that. It's not so much what Dr. Makrami relies upon. It's what we say is the three principles that are identified in paragraph 57 are indeed principles of Iranian law. The difficulty is that Neok, my clients, rely upon 11 principles of Iranian law, which we say are supported by the expert evidence of Dr. Makrami, or at least we have an arguable case that they're supported by the evidence of Dr. Makrami, and that there's a realistic prospect that there's an arguable issue as to whether we'll be able to establish those principles at trial.
Right. Well, one of the problems with Dr. Makrami's report is that he does all the things which English law says should not be done. That is to say, he tells us the ultimate answer, whereas his function, see the citation at paragraph 53 of the judgment, is to give us the principles, and then the English court applies them. So a certain amount of work has to be done on Dr. Makrami's report, other if you're not going to say the whole thing is simply inadmissible, to distill, maybe that's a word you don't like, but nevertheless to distill the principles. And if you say there are 11, then it might be helpful if you produced a table setting out the 11 principles with cross-references to the paragraphs of his report where they are set out.
Well, my Lord, exactly. And I'm good. Jumping ahead really to ground one, the detail of it. Since you've raised this point, it's a very fair point, if I may say so, in this sense that what we have is a claim, an arbitration claim brought pursuant to CPR Part 8, and as a consequence of that, we don't actually have any formal pleadings, at least not at this stage, at least not when the applications were issued by my learned friends. That was before there being any directions in relation to formal directions in relation to expert evidence, or indeed any direction that there should be a pleaded case on Iranian law, which is what perhaps normally, certainly in a Part 7 context, one would expect my clients, or whoever it is who's relying upon foreign law, to actually plead the relevant principles of Iranian law, whatever foreign law it is they're relying upon. And that didn't happen in the sense it wasn't a formal pleading. But importantly, and this actually goes to the heart of my case on ground 1, which is why I'm being diverted to it now, which I hope is going to be helpful. Importantly, the skeleton argument before the learned judge had a specific section which did precisely what your lordship indicated would be helpful. And the paragraph or section of the skeleton I have in mind is in this core. It's in the supplemental core bundle, which is core bundle 3 or core supplemental bundle. So this is the skeleton argument that my clients prepared in July of 2022, so 2 months before the actual hearing took place. So this was the skeleton that was before Mr. Justice Butcher.
Yes.
And the relevant section, which is important, particularly given the fact there was no pleaded case, is paragraph 16 at page 198. Yes, but we're behind tab 7. And paragraph 16, which runs from page 198 to 200, there are 11 subparagraphs, and this is NEOC's case on Iranian law. And what we submit is based on the evidence presently before the court. NEOC submits that the court should have regard to the following principles of Iranian law that are relevant to the construction of arbitration agreements governed by Iranian law. And then 11 separate principles are set out on which we rely, and there are references, cross-references to the various paragraphs or passages in Dr. McCrami's report, which we say support those principles. Now, I appreciate that wasn't a formal pleading. If it operated, we would submit in much the same way. And why that's important when we look at the Supreme Court's guidance about mini-trials is what the learned judge should have been doing is focusing on what we say were the principles of Iranian law which are relevant to construction, to determine whether or not they were arguable, or moreover, when we look at ground 4, whether it's reasonable to suppose there may be further evidence in the form of, let's say, a joint memorandum, and particularly cross-examination of the experts at trial, which could impact or may vary or clarify, make clearer whether those principles in fact do exist as a matter of Iranian law. That was essentially where he went wrong, because rather than focusing on our case as to what the principles of Iranian law are, which I agree wasn't easy, because Dr. McCramy, and perhaps it's unfair to criticise him, he's an Iranian lawyer, but...
Well, I think he did what he was asked to do. He was asked the wrong question.
My lord, I'm not going to... The way the question is put certainly explains partly why he did what he did, I accept that. But he does at least have a section, he does have sections which deal with the principles of Iranian law. And what we say what we say is relevant is not what the expert actually says, ironically. It's the evidence he gives as to what the principles of Iranian law are. This is actually a submission normally made in reverse. Normally it's person in my position saying, look at the report, look, the expert says this about the meaning of the clause. And in fact, the other side said, well, that's irrelevant. What really matters is what is the principles in identifying. So what we've sought to do, particularly given in mind the clear guidance from Lord Hamilton in the Court of Appeal and indeed Lord Longmore, which isn't in dispute, that the role of this court, or rather an English court, is to construe the words of the agreement by reference to the principles of Iranian law. What the experts on Iranian law think the clause means is unhelpful. I totally accept that. Ideally, there should have been a pleading, or at least in due course, we would submit if you were to allow this appeal, what would be appropriate, given the complexity of the issues of Iranian law, the fact it's a system with which is not familiar in terms of not a common law system. What would be appropriate is to be an exchange of pleadings, of which paragraph 16 would be a good start on the part of the deal, and then a reply report and a meeting and joint memorandum and so on. But in any event, why this is so important is because the judge should have approached the matter on the basis of, well, these are the principles New York relies upon. Do they have an arguable case to that effect, given the fact that Dr. Makrami's report is unchallenged? Should they be accepted? Well, we look at Kapabi's guidance in the Supreme Court, we would say they should have been accepted unless they were shown to be obviously wrong or inconsistent with the materials which he relied upon. And if they're accepted, then the question comes, when you get to ground 4, well, is there likely to be any further evidence, such as cross-examination, which would cast light, make points clearer, and so on? Could Dr. Makrami, when challenged, give an eloquent and persuasive oral answer in cross-examination, which made even more persuasive a point he'd made in his written report? Taking all those considerations on board, the court should then have asked itself whether the case that New York advanced, based on Iranian law, was arguable, or rather was not bound to fail at trial and merits the investigation that should take place at a trial rather than on a summary judgment interlocutory basis.
Well, the question really is whether, if these are the principles of Iranian law, assuming in your favour for a moment without checking them all that Dr. Makrami does indeed say they are, then was the judge's application of those principles wrong?
Well, my lord, that's the second part of it. He didn't actually articulate those principles. He restricted himself to the 3 we've identified in paragraph 57. My lord, for your lordship's note, just so this is clear, and so there's no inconsistency, what I've shown you in paragraph 16 of the skeleton argument for Mr. Justice Butcher, first instance, that paragraph is reflected, I think, precisely at paragraph 27 of the skeleton argument, our main skeleton argument for this appeal. So you will see exactly the same section, in other words, our case on what the relevant principles of Iranian law are, set out at paragraph 27 of our main skeleton for this appeal, which is the paragraph, page 30 of tab 2 of the core bundle. And the reason you might find that easier to look at is because there are references there and cross-references to the bundle where you can find the relevant passages on Dr. Makrami's report on which we rely.
Right, yes.
So I'm slightly out of my order, but I hope that was helpful. I'll try and come back.
That sounds very helpful, but if we're taking you out of your order, then go back to it if you want.
Well, I'm much obliged, Lord. I don't want to. I want to focus on the points that matter if I can. Can I just before going into the detail, just to make it hopefully clear, or hopefully some assistance, just give a very brief summary of what the 4 points we say are the errors the learned judge made. The first error, which is the subject matter of ground 1 of our appeal, is that what the judge adopted. We're going back to the judgment, it's probably the easiest place to follow these submissions. What the judge adopted, paragraphs 57 to 58, which is where he went through a process of distilling what he regarded as the relevant principles of Iranian law. And again, he did the same exercise in paragraphs 12 to 14 of his judgment on additional reasons. What the judge did, as demonstrated by those respective paragraphs, is essentially evaluate the evidence of Dr. Nakrami. And he exercised a judgment based on that evaluation for the purpose of distilling what he regarded to be the relevant principles of Iranian law. In other words, the task he undertook essentially is the one a trial judge would undertake once all the evidence of Iranian law is complete. And that was an error we would respectfully submit at an interlocutory stage. And what the judge should have been doing is focusing on the arguability of Neok's case as to the relevant principles of Iranian law, which, as I've shown your lordship, was before him, paragraph 16 of our skeleton argument, and same paragraph in your lordship's skeleton for this appeal. And what happened was that the learned judge was seduced by my learned friends into adopting the role of a trial judge and effectively conducting, in our respectful submission, a mini trial. And that was the wrong approach we would submit to evidence of this sort at an interlocutory application for summary judgment. And that essentially is ground one of our appeal. Secondly, my lord, and this is summary of ground two, if you go to paragraph 57, and these are independent grounds, so if you're against me on ground one, ground two still survives. So I'm assuming for the purpose of ground two, if you go to paragraph 57 of his judgment, subparagraph 2, he says there that Iranian law applies a restrictive approach in interpreting the scope of arbitration provisions, whereby, quote, there is a presumption that jurisdiction is only conferred on arbitrators to resolve those specific claims, disputes or controversies that the parties have expressly agreed and articulated in the arbitration agreement to be within the competence of the arbitrator. So the restrictive approach to construction is what he accepts is a relevant principle of Iranian law. Now, ground two, which I will develop in more detail, but just as summary form, the error he made in paragraph 59 is that having recognised that the appropriate approach is a restrictive one, he then in fact adopted a literalistic one, which was simply the wrong approach. And what it did essentially was compound the error that the judge had failed to properly articulate Neok's own case as to what Iranian law was and consider the arguability of that case on Iranian law and its impact upon the proper construction of the arbitration agreement. So that's summary ground two. Then thirdly, my lord, paragraphs 56, 59 and 59.3, what we submit is the learned judge asked himself the wrong question for the purposes of section 67 and section 31C of the Arbitration Act. The error reveals itself, we would submit, in paragraph 56, where he says, subparagraph 2, whether applying those principles does an argument that the scope of the arbitration clause did not cover the claim for CGC's liability have a realistic prospect of success. And then he said again in paragraph 59 in the second line, I do not consider that Neok's case that the relevant claim fell outside the scope of the arbitration clause. And likewise, perhaps most explicitly, this error appears in subparagraph 59.3, where the learned judge says, what is accordingly involved here is to ask whether the clause in referring to arbitration all claims arising out of or relating to the GSPC or its breach extended to a claim which might in the future be brought by one of the parties to the GSPC for damages which that party alleged that it has sustained by reason of its liability to a third party as a direct result of the other contracting party's breach of contract. Now, for reasons I'll explain in more detail, we submit that was an error in the sense it was the wrong question to ask. The relevant matter which Neok contends and has always contended was outside the scope of the tribunal's jurisdiction was not the claim for damages itself. I tried to explain this to my lady. The tribunal clearly had jurisdiction over the claim for damages. Indeed, claim for damages in relation to a liability to a third party would be within their jurisdiction. But the relevant matter, which was beyond the scope of their jurisdiction, was the narrower issue as to the existence and extent of CGC's liability to a third party under a separate contract. So that was the judge went wrong essentially. We can look at the law on this. It's possibly quite one of the few important points of principle on the summary judgment application, which is what is the meaning of the word matters in section 31C in the terms of substantive jurisdiction. And as I'll be submitting in due course, we say it in fact has exactly the same meaning as the word matters in section 9 of the Arbitration Act. So finding all that's a summary of ground 3, and of course I will develop these. Ground 4, paragraph 61. 61 is the paragraph where the learned judge effectively says that he's happy to decide the case at this stage, notwithstanding the fact that there's been no joint memorandum of experts, the experts have not had an opportunity to change their minds, and there's been no cross-examination. And he gives 5 reasons for reaching that conclusion. And what we submit, my lord, and I'll show you the case on this, is that the learned judge applied too strict a test when considering the significance of, or the potential significance of further expert evidence on Iranian law that could reasonably be expected to be available at trial. And just to try and give that some colour, take, for example, paragraph 16 of our skeleton before the learned judge. We set out the 11 principles of Iranian law on which we rely. The judge seemingly thought that only 3 of those, or at least that he felt it, he only distilled 3. He didn't actually consider the arguability of our case on any of the other principles on which we relied. But what we can see happened, or what went wrong, certainly in paragraph 61, is what the judge should have had in mind is, well, look at the case that NEOP's advancing in relation to Iranian law.
Well, I see the force of your point if you are correct in saying that there are a whole load of principles under your 11 principles which were not properly distilled down into the 3. So the judge went wrong because he said there are only 3 principles of Iranian law when he should have had the whole 11 in mind. But why should the judge, assuming the judge has been looking at the 11 principles, why should the judge ever assume that you are going to do better at trial than having your 11 principles accepted? Because, and if his view was, well, even those are not good enough, why should he not give summary judgment?
Well, my lord, that's a very fair question. The answer is that the first aspect of the answer is the learned judge should have had in mind the 11 principles that we have identified.
Yes.
If you're right, if you're right to suggest that his distillation amounted to the rejection of the balance of our case, which is not explicitly said, it's not clear why. If it was on the basis he felt that the evidence was not clear enough to support the principles that we had articulated, we relied upon, or if he felt that they were obviously wrong because Dr. Makrami didn't support them, then
he may have thought that they didn't actually assist on the question he had to decide. I mean, if you look at the 11th principle, what Dr. Makrami says is that, generally speaking, the arbitration clauses are not construed as including claims in tort. Well, he may well be very right about that. It's different from the Fiona Trust principle. But there isn't a claim in tort here, so the judge didn't need to discuss that principle because it has no possible application to what he's actually considering, which is the challenge to the jurisdiction in this case. So you can't just say, here are 11 principles, he hasn't looked at them. He might well have said, well, that's a very interesting principle, but it has no relevance to what I actually have to decide, which is whether this claim, that is the claim, the damages, quantified by reference to a liability in the other contract, is or is not within the arbitration clause. And when he says, I've distilled it down to 3 principles, he may have said, to decide that claim, that's all that I find in Dr. McCrami's report, which is relevant to that question. And if he's done that, then that is a perfectly permissible thing to do, provided he's done it correctly.
Well,
Is it not?
What you're describing, if I may respectfully say so, it's exactly the process the trial judge, once the evidence is complete, the trial should have undertaken. But let me just explain what I will answer your question. What is the relevance of the paragraph 1611, the fact that, as a matter of Iranian law, the words relating to are not broad enough to include a claim in tort? Why that is, we would submit relevant, certainly in terms of assessing not whether we're right as to our construction, but the question the judge should have been asking is whether we had an arguable case. In other words, whether there was a realistic prospect of trial of our construction succeeding. I'm not saying what does the clause actually mean, which is what essentially he did. So if he'd been asking the right question, namely, does Neil have a realistic prospect of success at the trial in due course when all the evidence is complete and the experts have been cross-examined, to establish that the words relating to are not sufficiently broad to include the determination of the existence of and the extent of the liability of a third party under a third party contract. In that context, the principle of Iranian law to the effect that a claim in tort is not related, even if it arises out of the performance of a contract, is not related to the contract or the breach of it, is, we would respectfully submit, a very helpful pointer to the right answer to the question with which the court would be concerned. And that's why the question of relevance at an interlocutory stage has to be addressed by reference to the question that's been addressed. In other words, relevance is it relevant to the question whether they have a realistic prospect of success, or to the fact that their claim isn't doomed to failure or bound to fail, as Justice Coulson recently put it at trial. So it's a slightly broader inquiry. There should be more latitude with respect to Smith at an interlocutory stage. I will show you a case of the decision of Mr. Justice Leggett, as he then was, in Edgeworth, where he talks about the very difficulties inherent in trying to make any formal conclusion based on expert evidence foreign law at an interlocutory stage. And that very much reflects, we would submit, the difficulty the judge should have appreciated he was in trying to deal with the construction at an interlocutory stage. He should have realised what really mattered was, do we have an arguable case?
So are you saying, for example, that the judge shouldn't really have perhaps gone behind your 11 principles, take them at face value, rather than interrogating what the expert had actually said?
Exactly right,
is
my
that your
lady.
point? So really, he should have, in other words, he should have stopped at the skeleton argument and not trudged his way through the expert evidence?
Well, my lady, no. Well, I'll show you the relevant principles on that, but just to summarise what they are. Firstly, there is Lord Hope in Three Rivers, where he does say that if and insofar as you can show the evidence is inconsistent or obviously wrong, it can be rejected. And then you have, as you'll see, Lord Justice Leggett, Mr. Justice Leggett, as he then was in Edgeworth, saying, and I will show you these authorities, saying that if and insofar as it's obvious that the expert is wrong, it should be rejected. And then you have Akabi in the Supreme Court adopting very much the same approach, namely, you should essentially accept the pleaded case of the claimant as being right unless it's obviously wrong, i.e. inconsistent with all the documents. So, but taking those principles, which I will show you into account, the answer to my lady's question is yes, the judge should have accepted the 11 principles, subject to my Lord Justice Nugee's point about relevance, which is a fair point, assuming they are relevant to the question that arises at summary judgment, namely, is there a realistic prospect of success at trial? If they're relevant to that question, then he should have accepted them unless they were obviously wrong.
But he's not rejecting them. He's simply saying, you say wrongly, that they don't get you home.
Well, my lord, it's not clear what he's saying, because what he did do was simply adopt the wrong approach. What he basically did, and it's relatively short, is that paragraph 57, he adopted the role of a trial judge, because rather than focusing and asking his question, focusing on our case and whether it's arguable, he actually went through Dr. McCrami's report, and he distilled what he considered to be the relevant principles from it, which is the job of a trial judge. What he should have done rather than evaluating the evidence before him at an interrogatory stage, you should have accepted my client's case. And I appreciate there was no pleading. I quite accept there was no pleading. But nonetheless, our case was on Iranian law was clearly, we would submit, concisely, clearly set out. Paragraph 16.1 to 16.11, the skeleton before him, which are reflected in the skeleton before your lordships. And unless those principles were wrong, and could be shown to be wrong, which is unlikely given the fact that Dr. McCrummey's report was not contested, there was no counterfeit, there's no evidence.
Well, it just doesn't say anywhere, I don't accept Dr. McCrummey's evidence about this. I think he's wrong. So I rather doubt whether it's going to be helpful to show us cases like Three Rivers or Edgeworth, if that's all that Edgeworth says. I mean, the question is whether the judge's distillation was a fair summary of what Dr. McCrummey was saying, and if it was, then does it lead to the conclusion the judge reached applying those principles? And if it wasn't a fair summary, does the whole set of 11 principles lead to a different conclusion from what the judge reached?
My Lord, I will try my best to address that. It may well be that I should start, because we're now into the meat of ground one, and so I refer you to paragraphs 32 and 32 to 47 of our placement skeleton article, which is in core bundle 1 at tab 2, pages 35 to 39. That's where our written submissions are set out.
Yes.
Now, what we say, this is a long-winded answer to my Lord's question, but I will address it. What ground 1 is about, or rather the point of principle it gives rise to, is what is meant by a mini-trial. There's plenty of dicta in all the summary judgment cases. You should avoid a mini-trial, but what is that? I mean, it's actually not really been very much guidance as to what a mini-trial is, and therefore perhaps it's not surprising that only last year the Supreme Court was saying that very distinguished judges of the Commercial Court and then 3 judges of the Court of Appeal went and conducted a mini-trial. Didn't even know they were doing it. But so what is a mini-trial is quite an important point. And the point of principle that's relevant is this, and there's no easy answer to it, is where do you draw the line between conducting a mini-trial, which is wrong, and subjecting the evidence that's used on a summary judgment application to a critical analysis, which is permissible. So what we get from the cases is you can critically analyse the evidence, but you can't conduct a mini-trial. And you can see that.
Well, what you do at trial with oral evidence is you decide if there's a clash of oral evidence, whose account you prefer, and that sometimes means rejecting oral evidence. And there's plenty of authority under Part 24 that you don't usually go through that process. You can, if it's obviously inconsistent with things that have been previously said or with the documents or whatever. But in general, the defendant to a summary judgment application says these are the facts. You have to have a pretty solid reason for saying I'm going to proceed on the basis those aren't the facts. But that doesn't stop you, seems to me, from looking at what the facts deposed to are and where they take you. And it's, I would have thought, every day fair for judges hearing summary judgment applications to say this is what the respondent says, but even taking that at its highest, it does not amount to a defence in law. That's what people do, and that's perfectly standard, isn't it?
Well, my Lord, as an analysis, that is perfectly legitimate. You can take the evidence at its highest. You ask, does this establish a defence in law? But, my Lord, this is a rather different case, because the learned judge didn't take the evidence at its highest. What the judge did was evaluate the evidence, assess its weight, and then distill, effectively made findings, conclusions as to what the expert evidence of Iranian law established. And that was the wrong approach. Reasons I'll try and explain by reference to Akabi and Edgeworth in a moment. Because what the learned judge should have done is effectively accepted my client's cases to the principles of Iranian law which he was relying,
unless it can be shown that those principles which we asserted were supported by Dr. McCrami's report were either obviously wrong, or inherently inconsistent, or totally irrelevant. And you could be sure of that, sure of it now. Had he asked those questions, we submit it would have been obvious to him that these were complicated points of Iranian law, a system of law that's not familiar to an English court. There was the prospect of further evidence and joint memorandum and cross-examination. And for all those reasons, it couldn't be said at this interlocutory stage that my client's case on Iranian law, at least what the relevant principles were, was bound to fail. You know, I could ask, when it comes to the trial, I can ask the Crescent's expert whether he agrees with, say, 16.9. And if he does, that's going to be even more powerful and more helpful than whatever Dr. McCramy may have said in his first report, which was considered as an interlocutory application.
My Lord, perhaps I ought to just show you the three cases. They shed some. They don't answer the dilemma which I identified. The dilemma being, where do you draw the line between critical analysis and immediate trial? They don't actually answer that, but they're not unhelpful. The first case which I mentioned is the Okpabi case, which is in Authorities Bundle 3 at tab 33.
Well, just before you go there, you mentioned your principle 9, 27.9 or 16.9. The tribunal's jurisdiction would only extend to the resolution of issues or controversies arising under another contract or relationship if it was specifically mentioned in the arbitration agreement, which you propound there as a principle of Iranian law. But when you actually look at the report that you've cross-referred to, paragraph 26.1, it doesn't quite say that. It just says, firstly, the starting point is that no other contract or relationship is mentioned in the arbitration agreement. It's making a point of fact about what the arbitration agreement says. It's not, in itself, setting out a principle of Iranian law at all. So this is quite a... I mean, it looks as if you are either glossing what Dr. Mokharami has said, or relying on something he said elsewhere in the report in paragraph 26.1. I mean, this is quite a tricky exercise that we're looking at here. If these are the 11 principles which the judge is being criticised for not appreciating were there.
And I was just going to, Calby, but I'll try and answer your Lordship's question about paragraph 26.1, where reference to paragraph 16 of the scheduled argument.
I only looked at it because that was the one that you particularly picked up on.
Yeah.
And it does seem to me to be a bit hard to criticise the judge for not appreciating a principle of Iranian law existed, unless it is pretty clearly said by Dr. Mokharami that something is a principle of Iranian law.
Well, Lord, yes, I take your point, my Lord.
I mean, look at that over the adjournment if you
Yes,
want.
I just need to get the right reference. I mean, 16.9, just get the right reference. my lord, the answer is, I think, that you have to look at paragraph 26 as a whole. I appreciate the reference in paragraphs 26.1. Because actually the whole of 26, which taken together, leads to that conclusion. I mean, 26.1 in a sense leads up to that point, because it says, firstly, the starting point is that no other contract or relationship is mentioned in the arbitration agreement. The relevance of that, of course, is that that leads to the essential point.
I mean, that's a true statement of fact. I
Yes.
accept that.
It's what? 25. I'll try and look at, if I may look at this over the short term, and give you a better answer. My lord, if you look at 26 as a whole, 26.4, for example, to put the third point another way, the words arising under the jurisdiction conferred on the tribunal does not extend to the assessment or resolution of disputes, controversial claims under the terms of a separate contract. Can I say now then, perfect frankness, that as an English lawyer reading Dr. McCramey's report, it's not easy, it's not straightforward. Accept that, frankly. And what we try to do in paragraph 16 of the skeleton form, the lane judge, and what we've done in paragraph 7 of our skeleton before this court, is do our best to articulate what our case is as to what relevant principles of Iranian law exist, and where we think they're supported in Dr. McCramey. But what we do say, on any view, is that those are the principles of law which we would expect and anticipate being able to establish at trial. And even if Dr. McCramey's first report isn't as clear as it might be on certain elements, that's our case, and we submit that what the learned judge should have focused on is the arguability of that case set out in paragraph 16, which is the equivalent of a pleading, rather than himself at this early stage distilling what he considered to be the relevant principles of Iranian law from the report. I hope that helps at least in terms of what our submission is. Can I go then, if I may, to Okpabi, which gives some guidance? As I say, doesn't produce the final answer on this, but it gives some help as to what is permissible at an introductory stage and what isn't. It was a jurisdiction application. But the relevant question the court was concerned with was whether or not there was an arguable case against the anchor defendants. And as we will see, the Supreme Court said that's exactly the same inquiry as one would make in a summary judgment application. And if I can take you to the following paragraphs very briefly. Paragraph 21. I'll do it this way rather than going to Lord Hope himself. Paragraph 21 of Lord Hamblin's judgment sets out the relevant paragraph from Lord Hope's speech in Three Rivers, where he identifies in paragraph 94. I think that the question is whether a claim has no real prospect of succeeding at trial, and that it has to be answered having regard to the overriding objective of dealing with the case justly. But the point which is of crucial importance lies in the answer to the further question that needs to be asked, which is what is the scope, or what is to be the scope of that inquiry? And then he gives guidance in paragraph 95. He explains how issues are tried at court. So issues of fact are tried in our courts as well as settled. After the normal process of discovery and interrogatories have been completed, parties are allowed to leave their evidence so that the trial judge can determine where the truth lies. And then he recognises some exceptions, and those are the ones we've identified, namely where it can be shown that it's clear as a matter of law at the outset, that even if a party were to succeed in proving all the facts that he offers to prove, he will not be entitled to the remedy that he seeks. So that's my Lord Justice Nugee's point, which is that if it can be shown
that even if I were to prove all my principles of Iranian law identified in paragraph 16 of the skeleton argument for Mr. Justice Butcher, despite that, I wouldn't be entitled to the remedy I seek. That would be one base on which to refuse summary judgment. And because he says that's a waste of time to have a trial, because even if you prove all those 16 points to be right, it doesn't make any difference because they're irrelevant to the actual outcome of the case. And then the second example he gives, by way of an exception to the point there should be a trial, he said it may be clear beyond question, so clear beyond question, that the statement of facts is contradicted by all the documents or other material on which it is based. So pausing there again, so that would be, if it was clear beyond question that the Neok's case as to what the relevant principles of Iranian law was contradicted by the documents or by the material set out in Dr. McCrommy's report, then that would be another basis on which it could be rejected. And then this is important because complexity is also a relevant consideration. The simpler the case, the easier it is likely to be to take that view, and resort to what is properly called summary judgment. The more complex cases are unlikely to be capable of being resolved in that way without conducting a mini-trial on the documents, without discovery, and without oral evidence. As Lord Wolfe said in Swain and Hillman, that is not the object of the rule. Rule being part 24, is designed to deal with cases that are not fit for trial at all. So that's the basic guidance set out in 2003, which Lord Hamblin says was clearly not followed by both Mr. Justice Fraser and the Court of Appeal in this case, who, as we'll see, undertook what he described as a mini trial. The next relevant paragraphs are basically 107. 107 through to 119. Although I should show you, if I may, paragraph 103 under the heading mini trials. This is where the discussion begins at page 762. Just to give you the context, between 103 and 104, the second, just after F, Lord Hammer makes the point, in this case the challenge was made on the grounds that the claimants had no arguable case against the anchor defendant. There's a subsequent passage where he says the test is exactly the same as summary judgment. Paragraph 105, he talks about the fact the pleadings were in a complete mess. So despite the pleadings, unfortunately, in this case, were in a mess. Obviously, there was no formal pleading in our case because we have a Part 8 claim. But that, in my submission, is actually a point of form rather than substance, because we did set out detail what at least we said our case was on the relevant principles of Iranian law. In paragraph 07, having cited a passage from Mr. Justice Fraser's judgment, he said the result is that instead of focusing on the pleaded case and whether that discloses an arguable claim, the court is drawn into an evaluation of the weight of the evidence and the exercise of a judgment based on that evidence. That is not its task at this interlocutory stage. The factual averments made in support of the claim should be accepted unless exceptionally they're demonstrably untrue or unsupportable. And then paragraph 108, Fraser J was clearly drawn into an evaluation and judgment of the weight of the evidence. And then paragraph 109, this was not a trial of a preliminary issue. It was not for the judge to make findings. Although he was no doubt put in a difficult position by the way in which the parties had chosen to present the case, and that's a reference to the fact the pleadings were in a mess, he should have insisted that the focus of the inquiry be on the arguability of the claim, which should be fully set out in the particulars of claim, rather than the weight of the evidential case. And they talk about the Court of Appeal having rejected the complaint that Mr. Justice Fraser conducted a mini trial and said that all he was doing was subjecting the evidence to critical analysis. But then Lord Hamilton says that is only going to be so in clear cases, as Lord Justice Carnworth made clear, referring to the EDF case and Lord Hope. Lord Hope, and this is a quote from Lord Justice Carnworth's judgment, little b, Lord Hope had spoken of a statement contradicted by, quote, in italics, all the documents or other material on which it was based, and such it has to be a clear case. And the last sentence is important. It is, in my view, important not to equate what may be very powerful cross-examination ammunition with a kind of knockout blow, which Lord Hope seems to have in mind. So again, it's another answer to my point Lord Justice Nugee put to me, namely, yes, if there's a knockout blow and it can be shown, you know, you're on the canvas at an interlocutory stage, then fair enough. But unless you get to that level, particularly in a complex case, it's more appropriate for a trial judge to make the decision based on all the evidence that's available at that time. And in paragraph 111, in my view, it's clear that Mr. Justice Fraser did conduct a mini-trial, far more than subject the evidence to critical analysis, as reflected in the findings he made on the evidence. This is borne out by the nature. Well, adopting that here, we submit that what Mr. Justice Butcher did is effectively that. He conducted a mini-trial. He subjected Dr. Mokarami's report to the same process a trial judge would go through, as reflected in the distillation he made as to what he said to be the relevant principles of Iranian law. And then, going back to the judgment, Lord Justice Hamlin goes on, the Court, in order to determine whether Mr. Justice Fraser had erred, the Court of Appeal itself was drawn into an evidential inquiry. Having decided that he so erred, the Court then embarked on its own assessment and judgment about the weight of the evidence. And you'll see references in paragraph 113 to what Lord Justice Simon said. He then set out his, quote, views of this evidence, expressed the view that the evidence provided scant support for the claimant's statement and that their evidence was slight, and so on, and excluded some expert evidence. You see that, Professor Siegel's, and that he wouldn't admit Mrs. Sedgwick's witness statement, and so on. And then he goes on to paragraph 115, having referred to what Lord Justice Simon did. He then says, Lord Justice Simon's conclusion was therefore clearly and expressly based on his evaluation of the weight of the evidence. It is right to observe the Court was put in a difficult position because, as Lord Justice Simon pointed out, by the conclusion of the argument before us, the claimant's case bore little resemblance to their pleadings, which had not been amended to take into account the developing case. The Court was therefore doing its best to address the case advanced before it, but it was thereby led into making evidential evaluation and judgment. So, in paragraph 119, as with Lord Justice Simon, this was a conclusion clearly and expressly based on an evaluation of the weight of the evidence. So, we would submit that case does provide some guidance as to the appropriate approach, and that what we respectfully submit is the learned judge was on the wrong side of the line, in the sense that he, in our respectful submission, he did conduct a mini-trial, in the sense that he, instead of looking at the arguability of our client's case on Iranian law, which we set out, by which I mean the arguability in two senses. One is, do those propositions on which we rely, are they at least consistent with, even if they're not explicitly supported by, are they consistent with Dr. Mokarami's report? Or should they be rejected as being inconsistent with it? And are they arguably relevant to the inquiry that the trial judge will ultimately have to undertake? And we submit that was the right approach, which the judge should have adopted, but didn't. And that's what led him into error, if we may respectfully say so. The other case, very briefly, I can mention just on this, the Edgeworth case, there's not much in it, but there's, as I say, there's scant authority on this area, so I do think it's appropriate to show it to you, Lordship. It's in Bundle, Authorities Bundle, Volume 1, tab 16. The decision of Mr. Justice Legacy then was sitting in the Commercial Court in a case called Edgeworth Capital and Glen Moore. There's no head notes. Perhaps I could just very quickly try and explain what the case is about. As we can see from paragraph 1 at the top of page 389, that the claimants are applying for summary judgment on their claim under a personal guarantee given by the defendant, Mr. Maud. And bottom of page 389, paragraph 7, the last sentence, the sole matter relied on as a defence to the claim for the purpose of resisting the summary judgment is an argument based on a provision of the Spanish Insolvency Act, namely Article 97.2. Then the argument of the defendant, paragraph 9, is recounted by the learned judge. The argument made by the defendant is that if the claimant's challenge to their classification is unsuccessful, Article 97.2 will require the court to make an order declaring, in the language of that provision, guarantees of any kind constituted in favour of the claims that party might hold to be extinguished.
paragraph 9 says the argument as a matter of Spanish law is supported by a witness statement made by Mr. Ramon, a Spanish lawyer instructed by the defendant. And in paragraph 12 across the page, you see the argument made by the claimants, the plaintiffs who was applying for summary judgment. And Mr. Mark Phillips, QC, said essentially that the point being advanced on Spanish law is, quote, in truth hopeless. Mr. Phillips argues that the literal interpretation of Article 97.2 of the Spanish Insolvency Act, for which the defendant contends cannot be, and is not correct because it would result in absurdity. Now, that was a pretty powerful submission, which, to be frank, Mr. Justice Leggett considered had considerable force. And he says as much in paragraph 16 and 18 and 19. 16, he says the views expressed by Mr. Malaga, he was the expert on the other side, totally disagreed with the defendant's case, had very considerable force. And then he says in paragraph 18, try as I might, I found it hard to see any sense in that explanation of what Article 97.2 is intended to achieve. And then paragraph 19, tempting as it is, however, to decide this issue by adopting what seems to me to be clearly the better view of the meaning of this provision of Spanish law, it's necessary to remind myself of the need to be cautious in dealing with questions of foreign law in English proceedings, particularly at such an early stage as this. Now, the early stage, of course, is the summary judgment stage that he's referring to. And paragraph 20 is important, we would respectfully submit. Points made by Mr. Arden on the defendant's behalf. First, that there is at present before the court no opinion on the meaning of the Spanish provision given by an independent expert. The opinions currently expressed on each side are from individuals who work for law firms acting for each party. Secondly, the evidence which has been given is not subject to the CPR provisions governing expert reports on the duties imposed by that regime. Thirdly, there is no full exegesis, and indeed the claimant's evidence contains no real exegesis at all of the legal methods which would be used to answer the relevant question of foreign law in the foreign legal system. In particular, there has been no full explanation of the applicable principles of statutory interpretation, the hierarchy of relevant legal sources, the status of decided cases and matters of that sort. Fourthly, I must recognise that the opinion given by the claimant's lawyer is contradicted by an opposite opinion, which is not simply a bare and unreasoned opinion, but is one for which reasons have been provided. There has at this stage been no testing of the opinions of the witnesses on each side, as would occur through the court process, including a meeting between experts if the case proceeds to trial, and most importantly, of course, I think in my submission the words most importantly, of course, was significant. Most importantly, of course, the process of cross-examination. I do not say that those difficulties automatically or necessarily would preclude the court from granting summary judgment. There may well be points on which foreign law is so clear that the opinion expressed by one lawyer is so clearly right, and that expressed by the lawyer on the other side so obviously wrong, that the points can be decided summarily. Pausing there again, that's a reflection, doesn't cite it, precisely the test that Lord Hope set out in Three Rivers.
The context for all of this is the caution to be exercised not to decide between competing points of view, isn't it? And that's what this case is actually about.
Well, competing in the sense that one expert said one thing and the other expert said another. What we don't obviously have that because the other side haven't even put anything up to contradict what Dr. McCramey has said. Exactly. So I agree that's a point of distinction, but that doesn't alter the general observations that Mr. Justice Leggett is making, is that at this early stage, the material before the court has, this is the point he makes in paragraph 25, I don't feel able to reach the conclusions on the material now before the court with all the inherent limitations which that material has at this stage of the proceedings. Now, why that's relevant is because what Mr. Justice Leggett's referring to is the fact there hasn't been a meeting between the experts. There hasn't been a formal report exchange between the experts governed by the CPR, and nor, as he describes it being most importantly of all, has there been a process of cross-examination. And that's why there are these inherent limitations which he refers to, which the material has at this early stage. We submit the very same points are relevant here, because at this early stage, all one has is a report by Dr. McCramey. We have no competing report, even though one of their friends have indicated that's the intention to serve a report, and there's obviously been no cross-examination. So to make a distillation at this early stage of what the relevant principles of Iranian law are, and then simply decide the case by reference to that distillation, rather than consider
what the points of Iranian law that NEOP relies upon, and whether they're arguable, and whether they could disclose an arguable case. That's why the learned judge went wrong in our respectful submission. He effectively treated it as if the clock stops now. The clock stopped in terms of evidence in the form of Dr. Makrami's report, and it was up to him to make a decision, final decision on the matter. That's essentially what a mini trial is. He adopted the role of a trial judge rather than an interlocutory judge, considering whether the case was fit for trial. In other words, what the learned judge didn't do is focus on the arguability of my client's case, which he should have done. And that's equally true of construction. I mean, there is one authority which makes that clear. It's a case called AC Ward and Catlin. It's quite old now. It used to be cited as the authority whereby this court approved the easy air formulation of principles for reverse summary judgment. But there is one revealing passage. Again, I'm not suggesting it provides the answer, but it points the right way, if I can put it that way. The reason I show it to you, because it's a case about the construction of a contract. In fact, the case paragraph, 70 of Authority Bundle 5 at page 1568, and the relevant paragraph I wanted to show you.
Sorry, which volume?
I beg your pardon?
Which volume?
Volume 5, tab 70.
Yes.
It's a very short point, my lord. I just want to show you paragraph 35. And the reason it's relevant is this, that this was a case about the construction of a warranty and a contract of insurance that was actually governed by English law. So there wasn't even any question of any foreign evidence, foreign law evidence being relevant. So we're dealing with an English law contract, a construction of that contract. And paragraph 35 is helpful, we would submit. As Lord Justice Etherton says, I agree with the defendants that neither the claimant nor the judge has articulated clearly any evidence relevant to the interpretation which is likely to exist, and although not available on the hearing of the application, can be expected to be available at trial. Had this been the only ground for dismissing the application, it would not, in my judgment, have been sufficient. Mr. Stuart Smith accepted, however, as I have said, that it is apparent from the paragraph 46 of the judgment that the judge's decision included the arguability of the claimant's submissions on interpretation. And then he makes some point about it being a standard commercial combined policy. And then the last sentence of that paragraph, in these particular circumstances, combined with the arguability of the claimant's points on interpretation, I can understand why the judge considered it would be appropriate to give the claimant the opportunity to seek and adduce any relevant and admissible factual material available by the date of the trial. So again, my lord, as I say, it's not a complete answer, but it points the right direction, in my respectful submission, and it's relevant because it's dealing with a case based on construction, a construction issue, which, of course, in a sense, is what we have here, namely determining what the proper scope of the tribunal's jurisdiction is.
Now, if it's a question of English law, construction of an English contract, it can be appropriate in particular cases for the court to grapple with the question of construction on a Part 24 application, can it not?
Indeed. I think the phrase is grasp the nettle has been expressed in various cases as to what you do.
Yes. So I'm not quite sure what this case is authority for, other than that in the particular circumstances of that case, the judge was entitled to take the view that it wasn't an appropriate case for summary judgment.
Well, my lord, I tried to be frank about the fact that I couldn't find any authority that was going to be determinative of the dilemma I expressed, and this was only pointing the way. The point I was relying upon in paragraph 35 is what Lord Justice Etherton suggested as being the relevant touchstone of the judge's decision below to refuse summary judgment. And the touchstone he focused upon is the fact that the construction, arguments of construction being advanced by the claimants in that case were arguable. And
and it was appropriate, he said, in that case, that they should be given the chance, even though they couldn't identify with precision exactly what other factual evidence might be relevant to that arguable case, given the chance to adduce that evidence at a trial. And what I suppose, to answer my Lord Justice Nugee's point, I agree, it's not authoritative in the sense of defining exactly what the role of the judge at summary judgment hearing should be. But what I would say is an approach that's wholly consistent and illustrative of the approach which Lord Hamlin and the Supreme Court endorsed in Okapambi. I can't put it any higher than that. That's what we submit.
Is the construction of the arbitration clause in this case, we know that the principles of Iranian law are, being a question of foreign law, treated as questions of fact. But we also know that once you've gotten those principles, it's for the judge to apply them himself or herself to the construction. Is that a question of fact? Is it a question of law? What is it?
Well, I'd say it's a mixed question of fact and law. It's a peculiar decision.
It's a very peculiar.
Because we know from Brownlee it's still not quite clear how you properly characterise these questions, because it's a slight fiction from the 19th century. It's never quite been corrected that we treat foreign law as fact. I mean, in a sense, it's easy to see why Iranian law should be treated as fact, because it's a system of law that's alien to our common law heritage. So it's a wholly different body or beast. But to treat some New York law as foreign, factual, is somewhat more of a challenge. But to answer my Lord's question, the aspect of the exercise has two parts to it. You plug in foreign law, and then the judge applies that to make a decision. So on any view, that part of the exercise which involves the material you plug into the exercise is a question of fact. Then the process the judge undertakes of construing the meaning of a contractual term by reference to principles of foreign law is, I would submit, a hybrid. I'll try, and if there's any authority on this, I'll try and find it. It might be something dicey and I haven't seen, but it's a kind of hybrid conclusion in the sense that it's a legal exercise, but by reference to factual evidence.
Thank you.
Perhaps do it after lunch.
Subject to that, is that ground one?
It is. I thought. I'm sorry. Hopefully the next sections will go more quickly. But just to summarise it, what we say is that the distillation process was simply the wrong approach, and that he went wrong. He should have at least considered, or at least articulated, what our case was on Iranian law. I mean, that reveals the error, really. Instead of actually doing that, focusing on what we said Iranian law was, and saying why we were wrong, or why he was rejecting it, or why certain paragraphs weren't supported by the evidence, or they weren't arguable. He just didn't do that. Instead, he adopted a different approach, that namely of a trial judge, saying, well, here's the evidence, I'm going to read it, and I'm going to make some findings. And that, at an interlocutory stage, is the wrong approach. So that's ground one. Now, I'll try and, ground two is, slightly more quickly, I hope. And it's this, that even if, so it assumes that the judge was right, to distill only those three principles of the law, set out in paragraph 57 of his judgment. Now, what we submit is that the learned judge nonetheless fell into error in paragraph 59.2 of his judgment by adopting a literalistic approach to the interpretation of the words of the arbitration agreement, rather than concluding that the words, rather than adopting a restrictive approach. And therefore, his conclusion that the words related to were wide and broad was wrong, or at least arguably wrong, or perhaps to put it another way, our client's case that adopting a restrictive interpretation led to an opposite conclusion was plainly arguable, or at least gave rise to a tribal issue, and ought to have been the subject of a trial rather than a summary determination. Now, the two reasons we say what the judge did were wrong, or other, well, two reasons we say it's wrong is, Firstly, it's inconsistent with Dr. McCramey's report, but most obviously, it's simply inconsistent with what the judge himself said. If you go to his judgment, go to the judgment at paragraph 57. Paragraph 57.2, Iranian laws applies a restrictive approach, and then bizarrely, and we would submit it's just a mistake. In paragraph 59.2, it says adopting a literalistic approach. The words used are wide, in particular the words relating to a wide. Category of disputes, controversy claims is broad. Now, that's obviously it's inconsistent with Dr. McCramey's report, but more profoundly, it's actually fundamentally inconsistent with the judge's own distillation of what he regarded as the relevant principles of Iranian law. Moreover, my lord, what the learned judge said in paragraph 59.2 is simply ignored the meat of our argument completely, and indeed, again, didn't stand up to an assessment of what the arguability of our case was. What I mean by that is that the learned judge ignored our client's case that the words relating to have no natural or ordinary meaning in the English language, particularly in the context of an arbitration clause. And what's clear, we submit, is that they depend for their meaning upon the policy considerations of the system of law by which they're to be construed. In a sense, we see that from Lord Hoffman's speech in the Fiona Trust, where he said, question here is construction of what the words mean relating to and rising under and so on. And the first point he said is they raise a fundamental question about the attitude of the law to arbitration clauses. And what we see, certainly in English law, and that's a reflection of the English language, is that the attitude of the English courts to arbitration clauses has changed fundamentally from the 19th century to now, when we're probably one of the most pro-arbitration, which I'm not saying, certainly in many respects a good thing, I'm not criticising it, we're now one of the most pro-arbitration jurisdictions in the world, but we weren't always like that. And in the 19th century, they had words like relating to, and they were given very, very different meanings. Just to make that point clear, if we look at Russell, if we have Authorities Bundle 5 open, at page, tab 67, my lords, at page 1537. Paragraph 2-103, disputes in connection with, in relation to, or regarding a contract. These words, which are frequently encountered and must be given the same meaning, were at one time given a restricted interpretation, and as reference 502, the footnote, to a case which is referred to at page 1539, as in Lawson and the Wolsey Local Board, where, quote, any difference concerning anything in connection with this contract was held not to cover a dispute about an implied term. Certain other work on the site should not be delayed. What Lord Hoffman would have made of that, I've absolutely no idea. But the significance of that is it shows that the words relating to, or in that case it was in connection with, but they have the same meaning, are given have no natural meaning, but are given a meaning by reference to the relevant policy considerations that are applicable in the jurisdiction concerned. Further point to that effect, we can see Mustin Boyd to tab, it's in the same bundle, my lord, at tab 65, I believe, slightly more detail, at page 1530. At page 1530, little b, halfway down the page 119, scope of the agreement is the topic under discussion. Little b, in connection with, in relation to, or in italics, and other words being considered. On the face of them, expressions of this sort would appear to be of considerable width. The current tendency is to enlarge rather than diminish their scope where the context allows. The courts have, however, in the past, given them a surprisingly restricted interpretation,
And then he gives a series of examples. They've been held not to cover a claim for damages based on the fraudulent inducement of the contract, or a claim for quantum meruit, or a claim for breach of an implied contract, and so on. So, in other words, there's no natural meaning in the English language as what in relation or relating to means. What's important is what the policy of the relevant jurisdiction is. And perhaps that's made most clearly by Bourne in his treatise, which we have a copy of, or at least an extract from at tab 57, in the same bundle at page 1447. And it's just a discussion. He doesn't actually talk about Iranian law, but it's nonetheless, we would submit, helpful in illustrating the point I'm making, where he says at 1447, not all authorities or national laws adopt the, quote, pro-arbitration approach to the interpretation that prevails in the United States, Switzerland, England, Italy, and elsewhere. On the contrary, a few authorities, mostly exclusively older ones, held that arbitration clauses must be interpreted restrictively, resolving doubts about particular disputes against coverage by the clause. The restrictive presumption is generally explained on the grounds that arbitration is a derogation from otherwise available access to civil justice.
Sorry,
And
which page are you reading?
I beg your pardon, my lady, it's page 1447, Authorities Bundle 5.
Thank you.
Sorry, I was trying to rush in the hope of finishing ground 2 by the shorter term, but if I'm going too fast, I apologise. The restrictive presumption, I'm just reading from the middle of the passage between the two hole punches. The restrictive presumption is generally explained on the grounds that arbitration is a derogation from otherwise available access to civil justice and the natural judge of the contract, and that such derogations must be construed narrowly, or that the arbitral process suffers from various deficiencies, therefore should not be encouraged, for example. And there's a reference to the Paris Court of Appeal saying all disputes related to the interpretation of the contract does not encompass disputes concerning the performance of the contract. These are examples. There's no point. They're all. What the irrelevance of this is, it shows that the words related to have no settled or natural meaning, and what they depend upon for their meaning is the policy considerations that are applied by the court in question. Fiona Trust is a classic example of that. So what we had in Fiona Trust was the consideration of a whole body of authority going back for hundreds of years about the subtle differences between the meaning of words like arising out of, rising under, in connection with, and so on. And basically Fiona Trust set all that aside, said it's all now irrelevant, essentially. All that matters is the presumption that we have in English law. We have a presumption. In Iran, they have a presumption of restrictive construction. In England, we have a presumption of one-stop shopping. So it really doesn't matter anymore what the nuanced meaning of particular words in your arbitration clause are, because unless you can get round the presumption that the parties intend all their disputes relating to this issue to be dealt with by the same tribunal, the words is irrelevant. That just shows the strength of the presumption in English law. My point is, the words relating to have no natural meaning, despite what the judge says, them being wide or broad. They depend upon the policy considerations. And the policy considerations in Iran are that you adopt a restrictive approach. Even the judge accepted that.
To say that you adopt a restrictive approach doesn't, by itself, tell you very much. Is it right to read Dr. Makarami's report at paragraphs 22 and 23 as telling us what he says Iranian law means by a restrictive approach, which comes down to his final sentence that if there is any reasonable doubt as to whether a particular dispute or claim or controversy comes within the scope of the arbitration agreement, it's generally determined against jurisdiction. That's what he means, isn't it, by saying restrictive approach?
Well, I think it goes further than that, my lord. That's certainly one example. Trying to.
It's
Sorry, it's
Supplemental 3, tab 8, page 1004.
I've managed to get myself clogged up with too many bundles. Well, perhaps the easiest way is just to try and show you just very briefly, some of the material that he relies upon. Perhaps that puts it more clearly. What we say, for example,
Just to take, for example, a section from a treatise by Mr. or Dr. rather Irashahi, which is at one of the exhibits to Dr. Makrami's report, at page 60 of the bundle, if you have that, where this is an extract from a treatise on Iranian law, and talks about violation of scope of the arbitration agreement. Well, that's a literal translation. What that means is a tribunal exceeding the scope of their substantive
So what page are you on?
page 60, my lord, of the same bundle.
You mean of the core supplemental bundle?
Core
I
supplemental
think
bundle.
my lord's looking at Dr. McCrum's report in volume 3. Of the
Oh, I
supplemental
see. I'm
bundle.
so sorry.
It was, yes. Is it in somewhere? It's in another place.
It's in the
as well.
core bundle, my lord. Yes.
Core supplemental bundle.
Core supplemental.
Oh, I see.
No, it's my fault, my lord. I just checked.
Anyway, all right.
Sorry. So big
put it
bundle.
there.
Probably best to look at it in the core bundle. If you ever take a bundle away, that's the better one to take.
Yep. Okay.
Supplemental
Sorry.
bundle 3.
Yes.
So we're looking at just a section. I want to show you two sections. Again, they're pointers more than they don't nail the question that your lordship asked me, but they give some help in answering it. So we're dealing with violation of the scope of the arbitration agreement, and first, different types of violation of scope of the arbitration agreement. Violation of scope, this means exceeding the jurisdiction. Arbitration agreement can be divided into different kinds. The most appropriate categorization, dividing it into violation of the arbitration agreement, the ratione materiae, and the ratione personae. Now, that's potentially relevant if we get onto the cross-appeal if permission is granted. Violation of the scope of the ratione materiae. In case of violating the scope of the arbitration agreement, the ratione materiae, a dispute or disputes being referred to the arbitral tribunal by one or more or both of the parties, and the tribunal has also considered and ruled on them, which are not covered by the arbitration agreement. This case can be raised under 3 following instances. So, what's been postulated here is the classic examples of where the tribunal will have exceeded its jurisdiction, its scope jurisdiction. And the first point is where the clause is not comprehensive, it doesn't refer to all disputes pertaining to the contract, and so on. And then secondly, and this is potentially important here, second, where the provisions and contents of several contracts have to be interpreted and performed in light of each other. Now, again, of course, this is a treatise. It's not dealing precisely with our case. But in my submission, that's a very insightful and revealing insight into Iranian law as to how an arbitration clause be construed. And what it demonstrates is that a classic case, one of the 3 classic cases where there's likely to be a violation of the scope of the arbitration clause, is where the provision of several contracts have to be interpreted and performed. And that's, we would submit, very close to what we say happened in this case. And in terms of restrictive interpretation, we can see from another treatise by Dr. Shiravi, which is at tab J, so page 101 of this Bible. And again, it's only at a high level because it's talking about the principles in the abstract, but as any treatise does, run by reference to a particular case. But the guidance one gets out of it are, firstly, at page 102, so below the second hole punch. For instance, in case the parties to a contract agree that any dispute arising out of the contract shall be submitted to arbitration, the Iranian court might decide by resorting to a narrow interpretation of the arbitration clause that the dispute as to formation or validity does not arise out of the contract, and set aside an award on the basis that it exceeds the jurisdiction. He does accept that the words all disputes related to the contract should be referred to arbitration, so stipulation shall be wider, or sorry, construed more extensive. But importantly, well, having said that, he then goes on to say, in this regard, the following points should be taken into consideration. Terms and phrases to be employed have to fully represent the intention of the parties' submission of their disputes wholly or partly to arbitration.
parties must assume that their arbitration clause might be interpreted narrowly. And he goes on, and as a consequence, making use of certain phrases which can barely cover all the disputes might be regarded by the court with care, so that a restrictive meaning be construed therefrom. So, my lord, this goes back, I think, to a question Lord Justice Nugee asked me, which is that what's the role of the judge here? In the sense, he has to establish what the principles of Iranian law are. But then it becomes an argument by us with the court, the English courts, what the actual construction of the contract is. What we're saying is that the argument at trial, and that's what would be advancing. I'm so sorry about the time. I think I've gone over.
Well, I probably distracted you into going over, and but there we are.
My lord, I've nearly finished round 2, and I would hope that it would take me about another 40 minutes at most to finish my submissions on some judgment.
Very good. All right, we'll adjourn now till 2 o'clock.